Well, hello, everybody, and welcome back to Radio Entrepreneurs. I really always enjoy this time of year, not just for the holiday season and the goodwill that people try to share with each other, but because it's time to sort of review the past year, look into the next year, make plans, be strategic. That is something I enjoy a lot. And with that in mind, and entrepreneurs, I think one of the best guests we could have would be Allan MacLean from MacLean Employment Law. Welcome back, Allan.
Thanks, Jeffrey. Good to be here.
Thank you. And as I told you off air, employment law always changing and potentially in conflict with many, many, many entrepreneurs and leaders.
Oh yeah, yeah. I mean, as we were just talking, in fact, entrepreneurs, they want to move fast. They want to get things done. And a lot of times I'm in the position as a counsel to them to slow them down in some ways. And I try not to do that any more than necessary, but you have to follow certain laws in terms of the treatment of your employees, whether you're taking actions against them for disciplinary action, termination, and the like, if you're paying wages, if you're withholding wages, taking leaves of absence, or administering those things. You need to be aware of these, just a broad range of issues. And sometimes business owners are just unaware of these issues and they just want to drive forward. And sometimes just taking a step back, slowing down is really the way to go.
Well, I understand entrepreneurs not being aware of these issues because entrepreneurs are focused on their business, the maintenance of their business, the growth of their business, the growth of their profit. And their job is not to study the law. And a lot of small employers don't have real HR departments. And even if they do, they might not be up to date. So it really is important to stay in dialogue, I would assume, with the proper attorney on what the laws are, because again, what a business wants and what the law dictates can be in direct conflict with each other, correct?
Yeah, absolutely. One law that comes to mind in Massachusetts in particular is the Mass Paid Family Leave Law. And so there's a federal law that we're probably more so familiar with, the FMLA, right? That provides for some protected leave, but that only applies to employers with 50 or more employees and some other criteria on top of that, right? Full-time employee that's worked for a year or a minimum of, I think, 1,250 hours in that year. But the Massachusetts law not only applies to smaller employers, which is a big difference, but it also doesn't have that extra layer of criteria, full-time employee, 1,250 employees. And the added benefit, which is generally a good thing, is it's not just a protected leave for employees, in situations like when they're having a child, adopting a child, maybe they have a health issue or a family member has a health issue. It applies to all those same situations, but it's going to provide pay on top, which is great for employees. But this does place a burden on employers, entrepreneurs, business owners to administer those leaves, or at least part of the leave, and to plan for it and to allow their employees to take the leave.
So I'm going to draw a line in the sand, and
Okay.
I love this debate because I'm coming at it as a management consultant and a serial entrepreneur myself. Most businesses are under 50 employees. Uh, the supply and demand has been bad the last few years for staff. Salaries have gone up exponentially. Small business is fighting to compete with large business in salaries.
Hmm.
And millennials are looking for culture. So if they're going to get a job and they're looking at a company over 50 employees, they're looking at great benefits. They're looking at a company of less than 50 employees. The entrepreneur, they can't afford to do 4 months maternity leave and the paternity leave. So they're not able to compete. So even though the law gives them a break, reality doesn't give them a break.
Yeah. And so, I mean, you're right. It's a much heavier burden on a smaller employer to have an employee out for an extended period of time because you need to fill in whatever work that person was doing with a smaller group of people, right, to step in. And that's a harder thing. And you probably have less resources available generally than a larger employer. One of the nice things about the mass system is that the pay for the employee while they're on leave will be paid out of the trust fund that's been created. And so it's not a direct burden, at least financially, on the employer during the leave. But that's not 100% true, of course, because there's a tax imposed on employers, and they do need to pay some. It's a relatively small percentage, but there is an amount that you're going to pay towards that trust fund. Now, for 25 or less employees, employers with 25 or less, you can shift that burden entirely to the employee. And so there is some recognition, I guess, for your concern there about really small employers. But that 25 and up range, we're lowering the threshold at a minimum. They do have to pay a small portion of taxes, and they do have to pay from the employer. They can't shift the entire total to the employee. And this year, actually in January, the percentages are going up, as one would anticipate would happen with these kind of laws, right? And so for employers with 25 or more employees, it's going from the amount was 0.63%. It's going up to 0.88% of wages that need to be paid to this trust fund is what it is. And that's for 25 and up. And for 25 and down, it's going from 0.318 to 0.41. And so again, you can shift that entirely to the employee, but the numbers are going up. And so, I think it's not as noticeable in paychecks yet or in the tax burden when employers are looking at what they're paying to the government for this. But it's going to start to creep up and they're going to start noticing that
Well,
burden.
there's another factor. First of all, I'm not a cruel person. Some years back, I had an employee who had very serious health issues, and voluntarily, my partners and myself, we paid a big proportion of their salary for over a year.
Right.
Person came back, took another job. Was not the best situation. But when in a small business, every employee is a critical employee. And if you're going to lose someone for 2, 3, 4 months, there is a residual effect on a small business that you may not ever recuperate from. So I do think that this is something that's very tough. And I think maybe if the government does want to get into business, they should look at small business and carving out a safer landing for small business versus larger business. And that would be my way. My
Yeah, no,
next,
that makes a lot of sense. In fact, though, I think the view, maybe recognizing the concerns that businesses would have with these leaves, actually has taken maybe the opposite approach of what you're suggesting. And because if an employer takes what I'll call an adverse employment action, typically I'm talking about termination or something like that, right? Within 6 months of a leave that's a paid family medical leave, there's a presumption under the law that it was retaliatory. And so the employer actually has an extra burden to overcome to show that they would have taken this action anyway. And they may be able to do that. For instance, maybe the employer has to do a round of layoffs and this person would have been caught up anyway. I've seen that. And that's a pretty good defense, but there is that extra hurdle. And then on top of that, the law also provides that if there is an adverse employment action within the 6 month period, it's retaliatory, then the damages aren't just the employee's lost wages. What would they have earned had they not been terminated, right? It's triple that amount. And so it's really putting a punitive measure in there purposefully to avoid employers from taking action, or at least to strongly consider what they're doing before taking action and be careful.
let me, again, I don't want to get myself in trouble, and I do try to be sensitive. And it really does say that an employer has to really be thorough when they're doing their interviewing and hiring. Yeah. But let's say someone hires somebody, and maybe I don't know if I shouldn't go here. I don't want anybody mad at me. Let's say somebody hires somebody who's pregnant, but the person interviewing doesn't tell them that they're pregnant. Is there an obligation on the part of the person doing the interviewing to say, hey, I'm going to be on maternity leave in the next few months as you're hiring me? There's no obligation on that part?
I don't believe there's an obligation. No.
An interesting...
The employer just has to take on that risk. At least that's what the law says. I mean, you can sort of debate, I guess, sort of the cosmic ethics of that. But I think the law says that an employer needs to take on that risk with respect to who they're hiring. And in fact, should not and would be prohibited from discriminating against someone on that basis alone. Then maybe there's some limited exceptions there. Let's say the job is a 2-month period job that you're hiring for, and the person knows they'll be unavailable, will not be available. Then maybe there's an argument to be made there. But that's a very limited circumstance, and even that you'd want to look at closely.
Oh.
So,
Well, times have changed, probably for the better. My first child was born. I took a week off. I was worried I was going to get fired.
yeah.
Different times, and I don't agree with that either. So I do
Yeah,
think
right. I mean, this is an improvement in that respect, for
yeah,
sure.
yeah. I was convinced I was going to get fired, and there were cracks. My boss made comments to me about taking that week off. You know,
Right, right.
uh,
Yeah.
let me ask you, employment law, was that something you always wanted to do, or did you sort of get directed into that, or there was an opportunity? I always find it interesting with business people, what was their path?
Yeah. I can't say I, always wanted to do it. I think that would be an overstatement. I think for me, I knew I wanted to do law in some form. I took a class on employment law. I liked that class. I enjoyed it. And I could relate to the material. Um, just about everybody's been an employee at some point in their lives, right? At least by the time they're an adult. And so you can relate to some aspects of these cases, right? Maybe not all of them. Some of them really go off the rails, but many of them, you could see yourself in the shoes of the employee or perhaps the employer. And so I think that to me was sort of what brought me to, want to become an employment lawyer. And then I was lucky enough to find an opportunity to start out working in the area.
I understand that because, people, if my first few years as a management consultant, people used to say to me, why? And I used to say, because I worked for many talented bosses, but none of them knew how to manage people
Yeah, yeah.
or get the best out of people. And I said, it was always a big issue for me that organizations didn't know how to get the best out of people. And I think that, organizations always are made up about people. Uh, do you see many changes coming? We're going into 2024. Any predictions in the new year?
Any predictions? I'll be interested to see and watching what the NLRB and FTC do on the non-compete front. There's been a lot of noise, not just noise. They put forward proposals to eliminate non-competes nationally in some form, and so I'll be very interested in seeing what happens there. If I had to make a prediction, I would say that it's doubtful they will be entirely just eliminated, but there could be some interesting activity on that front. And so I'm definitely monitoring that and watching that. Otherwise, I guess continuing to see what's happening with remote work. There's this tension that's building and I think is going to
Yes.
continue to exist amongst employers and employees, amongst who likes to work remotely and who doesn't. Are employees as productive as they could be? And there's competing arguments. I don't think there's a definitive answer. I think it depends on the situation and the person and the job. But there will be continuing developments there that I'll be watching as well. It'll be interesting to see.
Well, I think that that's a great topic to bring you back again on, because as far as I'm concerned, anybody over the age of 30 up, COVID created an expectation that never existed before, that I could have a better work-life balance and work from home and be more productive. And to just close the door on that and tell people to come back to work, it's hard once you create an entitlement, as you know. And people saw, they had the habit for 2 years of work-life balance. So I hope you come back. It's an exciting topic. It's an interesting one for me, one that I've always talked about before COVID, because I'm not a big fan of offices. I'm a big fan of productivity, and I'm always looking at how can you build productivity. Allan, if someone wants to know more about labor law, how do they find you?
So they can find me on my website, probably the easiest way, www.macleanemploymentlaw.com, or they're welcome to email me directly, amaclean@macleanpc.com.
Oh, that's great. And we hope you do come back again, and we appreciate your comments. I hope you don't mind mine. And remind everybody, this is Radio Entrepreneurs.